Alabama Students First Act of 2011, an overview by Lorian Charles. The purpose of the Students First Act is to improve the quality of education by ensuring due process for educators and provide school boards a means to effectively allocate personnel resources and maximize the use of limited funds. The individuals covered under the Students First Act of 2011 are certified and classified employees of K-12 boards of education, the Department of Post-Secondary Education, Alabama Institute of the Deaf and Blind, including workers of the Alabama Industries for the Blind, and the Department of Youth Services. It is important to note that those who already attained tenure or non-probationary status at the time Students First went into effect did not lose that status under the new provision. Employees who participate in the state merit program or employees who work fewer than 20 hours per week are not covered under this act. Non-renewals and terminations. A non-tenured or probationary employee will be considered re-employed unless written notification is received before June 15th in most years or by June 30th in a legislative quadrennial year. Tenured employees and non-probationary classified employees may be terminated at any time because of a justifiable decrease in the number of positions or for incompetency, insubordination, neglect of duty, immorality, failure to perform duties in a satisfactory manner, or other good and just cause as determined by the governing board of the organization. Tenured teachers must follow specific procedures to request a hearing or appeal a termination. Non-tenured teachers may be terminated at any time with at least 30 days advance notice. Reassignments and transfers. The following are the guidelines for reassignment. The superintendent can reassign any teacher within the first 20 days of students attending school. Tenured teachers may request a hearing before the board regarding a reassignment if they disagree with the movement. Teachers must be qualified for the position into which they are moving. Teachers cannot receive a reduction in pay as a result of a reassignment. Non-tenured teachers may not request a hearing regarding a reassignment, and teachers can only be reassigned one time per school year. The guidelines for transfer are similar to the guidelines for reassignment. In addition, tenured teachers may request a hearing if the transfer is outside of the feeder pattern of the teacher's original school. Transfers may be done because of a reduction in force, and in this case, appeal procedures used during termination would apply if teachers disagree. Suspensions. The board may suspend employees if they feel actions are necessary. Employees may be suspended without pay for up to 20 days. In this event, the teacher may request a hearing before the board but may not appeal if they disagree with the decision to suspend and it's carried out. Suspensions beyond 20 days require written notice and the same due process procedures as required for the termination process. Hearings. Tenured teachers have the right to request a hearing before the board regarding reassignments, transfers, terminations, and suspensions that last for more than 20 days. The rules for this process are included. The employee must file a written request for a hearing with the Chief Executive Officer within 15 calendar days from when the notice was issued. The hearing must be scheduled between 30 and 60 days from the day written notice of the hearing is issued. In the hearing, the burden of proof will be on the Chief Executive Officer of the school. The employee has the right to request a private hearing and to request subpoenas for witnesses to be present during the hearing. A decision must be sent in writing to the teacher within 10 days of the hearing. Appeals. Tenured teachers have the right to appeal a decision if they are opposed to the decision made after a hearing. The rules of this process are included. An employee must file a written notice of appeal to the Alabama State Department of Education within 15 days of the receipt of the decision, and he or she must also send notice of appeal to the Chief Executive Officer of the school at the same time. The school district will send hearing documents to the hearing officer within 20 days of the receipt of the appeal notice. During the hearing itself, deference is given to the decision of the employer. A final ruling, either affirming or reversing the decision of the employer, shall be rendered within 5 days after the hearing. Reduction in force. Reductions in force, compensation, workday, or work hours are not considered a termination or transfer, and therefore are not subject to hearings requested or appeals. The following stipulations must be met in order to take such action. The reduction or modification must be prospective, not retrospective. The reduction or modification must be based on a superintendent's recommendation and approved by the board. It can be done only if there are unavoidable reductions beyond normal attrition or due to decreased student enrollment or a shortage of revenues. It must be applied to employees in similar positions. Partial cancellations. Partial cancellations, or reductions in pay based on the length of the workday or school year that affect a class or group of employees, are not considered terminations or transfers if the action is prospective in effect, that means in the future, it is recommended by the superintendent and approved by the board, and it is applied to similarly situated employees within systems, districts, or divisions. The Students First Act of 2011 has changed the way teachers and employees earn tenure or non-probationary status. Employees must work 3 consecutive years beginning on or before October 1st. They must have a professional educator certificate the entire 3 years, and they must not have received written notice of termination by June 15th or June 30th, depending on the year. That's to earn tenure. Service as a classified employee does not count toward tenure as a certified employee, nor do years as a certified employee count toward tenure as a classified employee. Tenure does not apply to superintendents, CFOs, and employees who are piloting programs or working for temporary programs. In conclusion, the Students First Act returns primary authority for conducting personnel hearings as well as deference for decisions made regarding employment to the employer. However, the Students First Act frequently states that no decision should be made for political purposes or personal reasons. There are several excellent resources available on the internet to provide further insight into Alabama's Students First Act of 2011. The Alabama Educators Association offers the entire bill on its website, and CLASS offers a very helpful PowerPoint on its website. Both these and other valuable resources help employees and administrators alike fully understand this very important new law.